What I want to do is to introduce you to some of my work, some of which was funded by INET. That's the second part of the paper, but I would like to give you first like the theoretical foundations of this work. So one of the foundational things is to say that how we think about financial markets determines how we regulate them. So the theoretical concepts are really important. It's not something that academics do, but our conceptual frameworks really, really matter in the end. And so I think I want to argue here that what we need to think about is the role of law in finance, and I appreciate that this is already very much part of the debate here, but I want to go one step further and really argue that financial systems are structured in law. We have to understand the deeper structures of law. It's doing more, I believe, than just setting incentives or aligning incentives of the actors. It's actually shaping the very financial systems that we have. And we have basically two systems of law that interact in that fashion. One is the system of private law, the private law institutions of contracts, property, and collateral law, trust, corporate law, these types of institutions on the one hand, and on the other hand we have the set of public regulations, and they interact in a very dynamic fashion, and I think that really shapes the way in which financial markets develop, and also the kind of crisis that we do see from time to time. I want to start by saying that we have to recognize two important things. One, and that is sort of very much staple in the economics debate, contracts are incomplete. We know that. Private parties cannot possibly foresee all future contingencies, so they cannot write complete contracts. There's also always something that is not resolved and cannot be resolved. There's too much transaction costs involved, and of course we also face something like fundamental uncertainty in the sense that Jack Knight has defined it. I want to just add to that, and that goes back to work I did with Changgang Xu in 2003, and the papers in the package, to say that if contracts are incomplete, it's not so hard to understand that, of course, law is also incomplete. If two parties cannot see all future contingencies in their contracts and make amends to them, then clearly a lawmaker cannot do this, and actually a lawmaker doesn't even want to do that. A lawmaker writes very general laws because they're supposed to apply to many different cases, and they're supposed to last for a very long time. But if law is incomplete, then of course we have to think about how do you complete law when you apply it to specific cases. Effectively, we are delegating the act of completing the law relatively, never absolutely, to law enforcement agents at some future stage, right? And the uncertainty that is involved here is of the open-endedness of this. We don't know who is going to enforce the law, how exactly they will apply the law, gives us a lot of room to play with. And that's the room that private actors have to shape the law in the end. So incomplete law is enforced by courts or regulators. Courts are what we called in this 2003 paper reactive law enforcers. They can take actions only if somebody comes to court, right? And that means that they're always a little bit more passive than other actors have to be. That also means that they can't really prevent crisis. We have some preliminary injunctions, some mechanisms where courts can be proactive, but again, parties have to come to court so that they can take actions. In contrast, regulators can be more proactive law enforcers, and it depends a lot on how we design them, how much proactive law enforcement powers they have. They also have some lawmaking powers also at the ex ante stage, not only at the ex post stage. So that basically sets the stage for thinking about what are the ideal enforcement agents in areas of society where we might expect a lot of damages in the future. So if you have the threat of major damages, you may want to have some proactive law enforcers who can prevent, not only take care of damage remedies ex post. So in finance, Changgang Xu and I argued in this 2003 papers, we shouldn't be surprised that we see a lot of regulators because we need proactive law enforcement powers of these regulators. Okay. As I said before, in the space that we have between incomplete law and the state at which somebody will complete it because he or she is enforcing this law, we have a lot of room for trying to play with the law, and that's what the private sector does. The private sector is designing contracts. The private sector is trying to code different types of assets that could be collateral assets or not in financial systems. This is more flexible than it would have been with land or some tangible objects. They use trust and corporate law to shift assets, to shield liabilities. That's what the private sector does. That's what financial innovation is all about. Financial innovation essentially is legal innovation. It is playing with the basic tools of private law. And if you look at any derivatives or securitization structure, that's exactly what you find. You find contract, you find trust law, you find collateral law, you find attempts to play with bankruptcy law, which however is mostly a state monopoly, so that's a little bit more difficult. You need to lobby the legislatures for that. But for the most part, the private sector can do a lot without having to go either to the regulators to lobby or to the legislature if there is sufficient incompleteness in the law. And that's what they do. That's why so many lawyers make so much money. That's why you write very complex contracts. This is where the money is ultimately in a highly regulated systems. It's in the gaps between the regulations and the law. So this is where I want to come in with this project on my legal theory of finance, which I developed with a grant, with the help of a grant that I got from INET in 2010. We had a collaborative research group that was trying sort of to develop a new approach to the relationship between law and finance in response to the great financial crisis, of course, and in response to our frustrations that the standard law and finance theories just didn't really get at what had gone wrong. They had basically standard explanation. There's an exogenous shock, something went wrong, we now have to fix it, and after that we can sort of go back to the standard model, and we try to get deeper. I just want to say at the outset, this theory is fully compatible with the rational actor model. At the outset we thought that this is something we had to criticize. We really realized as we moved on that what the real issue was is the deeper structure of the financial markets, and in fact the legal structure of financial markets that we have to understand better to think about why they sometimes blow up. So there are four building blocks of this legal theory, which is still a little bit work in progress, but I just want to sort of say these are the core aspects of this theory. We're exploring it, we're trying to deepen it, we are doing case studies. I haven't quite brought it to large end studies yet, but I'm at the stage of doing that as well. So financial markets are legally constructed is the basic premise here, and I just basically put these two areas of the law, left and right, of the instrument, of the financial instrument that we might be talking about. On the left-hand side, you see again the institutions of private law, property, collateral, trust, bankruptcy law, and then of course state money, that's sort of the asset in which we would like to convert all other financial assets at some point in the future. That's always the assumption that we can do this, and of course it turns out in financial crisis that we can't, and that's when we have a run on assets. On the right-hand side, we have a regulation, and that can be either functional or structural. That's basically the scaffolding, as one of the lawyer friends I have in New York has called it. The regulations is a scaffolding, and what lawyers do is they're trying to design instruments within the gaps of the scaffolding. You don't want to violate the law, because then your financial instruments is not very not worth very much, but you want to also avoid the costs that are associated with the regulations, so you're trying to fit them within the regulatory scaffolding. Another basic building block of this theory is that financial systems are essentially hybridic. They're never just private or public. If they're public, we don't really have much of a financial system, but they're clearly never just private, because the state is always in. The state fashions the law, both the private law and the regulations, and it's in this interaction between private players that are designing new instruments and state regulation that the financial system evolves. And then last but not least, the financial system is inherently unstable. It crashes from time to time for reasons I will explain in a second. In that situation, only a state can rescue the financial system from self-destruction. Only a state with the power to backstop the system. Not all states are capable of doing that, and that's sort of another point I will come back to later. A core feature of this legal theory of finance is the law and finance paradox, and that basically says the following. What private parties are trying to do is to create binding commitments. Now, contracts is incomplete, we understand that, but at the same time, a major attempt of sophisticated lawyers is to shift the risk of dealing with future uncertainty to the other party. You can't eliminate this risk from the system, obviously, but you're trying to shift it to somebody else. And you do this through mechanisms that are well understood. We do collateral calls, margin calls. If something goes wrong in the future, you will have to put up additional money. That's one way to shift the risk of dealing with future uncertainty to the other side. Given these type of legal commitments, and we have, of course, fundamental uncertainty, it is not surprising that we sometimes get stress in the system, because if it turns out that too many people have to make margin calls, collateral calls at the same time because something happens that is a contingency in light of the contract, that then sort of forces everybody at the same time to find new capital, find new assets to deal with the same problem, then you can get into a crunch, you get a liquidity crisis, and you might end up in the extreme in a fire sale of assets, and that can lead to the system's self-destruction. So the deeper point here is that even without herd effects or any of that, just thinking about the legal structures that we have created in complex financial systems, we can set the system up for being on a track that brings it to self-destruction. Because you're building contractual mechanisms that mean that so many people at the same time have to respond in a particular way that would be foreseeable had we access to all the contracts, because of course we don't, and we don't know what the triggering event ultimately might be, but it could be a drop in housing prices. That's what happened with many of the securitization and derivative structures in the housing crisis. They were all tied to markets declining by a certain percentage or below a certain price, and when that happened on a massive scale, you could have predicted that the system would self-destruct. That brings me to the final building block of the theory, which basically says, once this happens, only a state can rescue the system from self-destruction, and it can do this in two ways. It can basically suspend the full force of the law by saying you can't enforce these contracts, or by offering liquidity where actually no liquidity is owed. And that basically means to give liquidity to entities and individuals who have never paid insurance to get that, who are not subject to the regulation that is typically required in order to have access to central bank liquidity in particular. So what this means, access to liquidity, of course, is access to central bank money. Everybody wants to convert their assets, which they have created under private law, in the last instance into cash, because that's the only asset that is worth at the very end. So law's elasticity is another feature of the legal theory of finance. At the one end, it has this rigidity. That's how it's designed in private contract. At the other end of the spectrum, once you are in the middle of the crisis, the only way to get back from that is that you make the law more elastic. That also explains why the law and finance paradox is actually a paradox. Right? Because you can't get out of this, you can't within the law resolve the issue. You have to really suspend the full force of the law to deal with a crisis moment. Now, what explanatory powers does this theory have? I think I've had some conversations around the day yesterday and over dinner yesterday, and of course one of the big questions is, does it have anything to say about India right now? What I do realize is that India currently is in a situation where, let's say, the public regulations might dominate vis-a-vis the private making of financial instruments and the private dynamics of financial markets. But I would like to remind ourselves that we've had a series of crises in emerging markets that, in my mind, have very similar pattern to what we've seen in the great financial crisis in the US, UK, and of course then in the rest of the world. So clearly, I think the great financial crisis can be explained in these parameters. I think the origins of this crisis lie in the securitization repo derivatives markets, the private instruments that were scaled up to a level where they were not sustainable, and when everybody was trying to convert them into cash, it turned out that they couldn't do so. This is the heart of shadow banking. Shadow banking was designed in the gaps of the regulatory scaffolding. It was getting around the regulations that were put in place to do exactly what you wanted to do within the regulations, but at lower cost. So you use repos, and you use money market funds, and you use off-balance sheet structures. These are, of course, organized as trusts, rather than doing the same activities through the banking sector. But I think you can also explain the East Asian financial crisis with the help of this theory. I have a doctoral student who is working on the Thailand financial crisis, and we're basically saying the theory, sort of the classic theories of this is crony capitalism, or maybe their herd effects are just not valid. And when you really look into the institutional structure, whoops, this is where my 15 minutes is up. I think you can explain this crisis. I think you can also explain other crises like the Mexico-Turkey crisis, the Russian default in 1998 in similar terms. And just to be clear, so it doesn't happen immediately. It takes time to build these kind of markets, but Russia was like 8 years after it started liberalizing, or 7 years after it started liberalizing, it found itself in a major financial crisis. So let me just say just 2 words and then I really stop about what's going on in India right now. So I think what we, just in general, what we really face, of course, in regulation, we always face sort of the problem between adaptability and accountability of regulators. So this is an important issue. We talked a lot about this yesterday. And of course, the degree of the incompleteness of laws and regulations has an impact on whether we can hold regulators accountable, but it also has an impact on whether or not regulators can respond to a financial crisis. So flexible responsiveness requires, more incomplete law, but it sort of undermines, of course, accountability. And there's just no easy solution to that. I just want to put this on the table, that as long as we think we just have to sort of try to control regulators, and I do understand the impetus, particularly in India, that people do want to do this. But the more we constrain them, the less hope we can have that they will be able to respond easily to new evolutions in the marketplace. There's, as we go forward and have relatively incomplete laws at the same time, of course, we also have more space for private innovation, and that can go the other way as well. On the draft Indian Financial Code, since you were so kind to send it to me, I just want to say a few words about that as well. It's really a remarkable, comprehensive piece, and it's trying to design a financial architecture of a kind that I think you could hardly do in any country. I'm not sure whether you can really push this through in India, but this is it's great to have this as a blueprint. Politically, it's difficult to change the rules of the game, but I think it's interesting. What I also find remarkable, I think it does really reflect the state of the art in international financial regulation. I do find some similarities in US regulation, EU, etc., but also some genuine new stuff. So I think the open question then is, first of all, is whether actually the international best practice standards are sufficient to deal with the kind of problems that I'm trying to outline here, that these financial systems are inherently unstable, and that law is part of the problem of instability. It's not just the answer, it's part of the problem. And that you have to look at these 2 parts of the law, the private sector law and the public sector law, to really get at that. And I don't think it's quite sufficient. I don't think that the responses to the great financial crisis have been sufficient on that front. The financial innovation, of course, has started immediately after the new regulations came down. And nobody can actually easily touch what is going on in private law unless you want to compromise the idea of the private autonomy in contracting, etc. And the second question is whether it is actually enough for countries on the periphery. One thing I haven't mentioned yet, but I just want to throw this out, we'll come back to that in the final session today, is that financial systems are inherently hierarchical, and in the global system, some countries are at the core or the apex of the system, and others are on the periphery. The US clearly is at the core. It provides us with the global central bank so far, maybe in cohort with the Bank of England, but they are at the top of the system. Everybody else comes below. And then you can think about where countries might be in terms of the global hierarchy. If you are on the periphery, you may have fewer options to rescue yourself, and then, of course, that sort of would then cast a shadow on what kind of regulation and governance structure you might want to have for the financial system.